Morning. It is my pleasure to introduce to you our panelists for the first session of the symposium. To my right is Megan Wood, who's a research attorney at the American Bar Association. To her right is Chris Gowen, who is a senior staff attorney at the ABA, Criminal Justice Section, and Lisa Thurau, who is the founder for Strategies for Youth. Together, they have co-authored an article together. We also have Aaron Kupchik, who is professor of sociology and criminal justice at the University of Delaware. He has co-authored an article with Professor Jeff Fagan. And we have Lisa Campbell, who comes to us from the Defenders Association of Philadelphia. She, with Riya Shah, who is the staff attorney at the Juvenile Law Center, have co-authored an article together as well.
I believe I'm first. So first of all, thank you, Jane, for the wonderful introduction. And I definitely want to thank and really commend the Duke Law students for picking this topic. My colleague, Lisa Thurau, and I always talk about how there's plenty of attention about reentry and collateral consequences on the adult side, but very little attention on the juvenile side. And so we want to thank you very much for bringing this to your school and letting us come here and talk about this. I also we want to give a special thanks to Lanta, who's been phenomenal in organizing this. You know, coming from the American Bar Association, I can certainly appreciate how hard it is to put together one of these events, and you've done just a phenomenal job, so thank you so much. Now, since I'm here at a law school, I'm going to do just a quick issue spotting activity here on these collateral consequences, and then turn it over to my colleagues for a little bit of analysis and conclusion. I think I'd be doing this. The topic today is collateral consequences of juvenile adjudication. I think I'd be doing it an injustice if I didn't comment on what I think is the biggest problem with regarding collateral consequences of juveniles, and that is the transfer of juveniles to the adult system, or categorizing juveniles as adults when they're either 16, 17 years old. This is becoming just an enormous problem in our country, and our country transfers and tries more juveniles as adults than any other country. And part of what we do at the ABA is we do the juvenile work, but we were also the grant recipient for the Department of Justice's huge grant to categorize the adult collateral consequences of convictions. And there we've uncovered 40,000 statutes that consist of a collateral consequence, where it's a law, an actual statute that denies an opportunity for somebody who's been convicted of a crime. And it's important to think about that, because when you take a 16-year-old kid, a simple analogy is can explain this. You look at a 16-year-old kid and a 56-year-old kid that are, convicted for say methamphetamine, and they both get sentenced to 10 years, and when they come out, you have the 56-year-old is now 66 years old, and with a life expectancy of 78, he's going to experience another 10 to 12 years or more of being denied opportunities for employment and food stamps, and et cetera. Whereas the youth is 16, he's 26 years old, and his whole life is ahead of him or her, and they're going to be denied opportunities for the rest of their life. And so I think, when I'm training public defenders, and when I was a public defender, and when I'm representing kids now, I think it's important to make the argument to the prosecutors that you're in fact sentencing the juvenile to a harsher sentence than the adult. And the Supreme Court in Roper and Graham have said that juveniles are different, and that they should be are less culpable and should be treated that way. And so they're not even equal now. We're talking about a greater punishment when you're transferring. So I think that's, in my mind, the biggest problem here, because instead of the juvenile situation where you have a lot of discretionary disqualifications. There's a lot of, whether it's housing, which you'll hear about, or education or employment, there's people with discretion to deny an opportunity for that juvenile. Whereas once they're transferred to the adult, it's automatic. They're not going to be able to get numerous amounts of jobs, food stamps, voting, I mean, and the list goes on and on. So I think, it's important to frame that. Now, I'm going to touch on just a few issues, and so we're clear what we're talking about here is we're talking about a situation where the juvenile has been sentenced, they have completed their sentence, they're not on probation, they're not on parole, they're free to go back to school, free to be back to enter society, and they find themselves being denied opportunities. And so the court said, you're done with the sentence, but yet society says you're not. And the first issue I want to touch on is education. In education, we see several different issues. One, you have being, as Jane referred to, being expelled or suspended from school because of an incident. Now, when the incident occurs on school's campus, I think there's a reasonable argument to, if there's a safety issue, to suspend a kid. But what we're seeing is that the kids are being suspended for incidences off of school campus. So the court system or the prosecutor's office will contact the principal, and the principal will then suspend or expel the student. And so I think that that's a big problem. And And so when they're suspended or expelled, you're missing school, obviously. And then you're also taking part in a case. And when you're a juvenile defender, you're almost always going to be, your trier of fact is almost always going to be a judge. You don't get a jury. And so when you're going in front of a judge trying to win a case, you have to really do your homework, and you have to win the case on the law. I mean, it's very hard to win it on facts. I mean, unless you have just unbelievable facts and a cop that's done a very bad job in his work. So what that leads to is several continuances, the process lasting, because you need to take your time to do your investigation. And so what tends to happen here is you have kids having to come to court 5 or 6 times before their case is tried. They've been suspended or expelled, so they're missing, up to 10 days there of school. And these days keep piling up. And the next thing you know, they've missed too many days and they're going to be held back. And then what you see is so many of these kids, when I was a student, when I was a lawyer, when I was a public defender, I'm still a lawyer, right? At being 16 years old and in the 9th or 8th grade or below. And therefore they can now drop out of school. And that's the sad effect that happens. So I think, we need to make a serious effort to keep kids in school, and especially when the incident is either an arrest only or off a school campus. I mean, if it's an arrest and they're found not guilty, they're essentially innocent. I mean, when you're arrested, you're still innocent. And so having that unilateral act by the school on that regard is problematic. When you get to the college level, we're talking about a discretionary disqualification. Here at Duke and at UNC, the application for, and the Common App, but at Duke and UNC, the application for admission asks about everything under the sun, convictions to arrests, to adjudications, and so someone who's just simply been arrested will have to put that on their college application, and that could possibly deny them admission. Now, it's impossible to know whether it will or whether it won't, but the fact that it's asked when an arrest could simply, once again, be an innocent person is problematic. And there are places that do it right, or do it better at least. The New York school system, the SUNY, only asks about convictions. Have you ever been convicted of a crime? And that's it. So a juvenile has been adjudicated does not have to answer that question yes or no, as long as they understand that distinction. And so one thing we've been advocating for at the ABA is to make sure there's sort of a parenthetical included on the application that says conviction does not mean adjudication in juvenile crimes. But your common application, which is your most common way to apply for college, asks about adjudications, findings of guilt. And so these words that are used are very problematic, but once again, it's a discretionary disqualification, so it's hard to develop policy around how to address it because the admissions committee can simply say, well, we don't give it much weight, but we don't know. And so that can be a problem. With graduate school, as all of our law students in the back here are familiar, you have to answer all these questions, because with graduate school, it's always going to relate to the licensing body for what kind of job you're looking for. So when you're going to law school, you're trying to be a lawyer, the state bars are going to have significant impact on what the school's going to ask you about. And so for example, in Florida, the state bar will even ask you about cases that have been sealed or expunged. So, the state bar is basically, license all these lawyers who developed laws to say, we need to have a law that says a juvenile should be able to seal or expunge their case if they've shown remorse and a set of standards. And when they do that, that means that no one can view their case if it's expunged, or only law enforcement if it's sealed. But then they say, on the other hand, when you're trying to be a lawyer, we get to see everything, and that doesn't mean anything. So it's problematic. When we say sealed and we say expunged, we need it to mean sealed and expunged, and there needs to be more opportunities for that. I'm not going to get too much into public housing because there's going to be another session on that, but what I will say about public housing, I'll share a story from as a public defender. When you see these cases where a family is facing eviction because of a child's alleged arrest, you can see some very upsetting things. And what we would see is parents coming in and asking the prosecutor to put their kid away, for the state to take control of their kid, detain this kid, and exaggerate the facts of the case so they don't get evicted. So they basically rather give up their kid than be evicted. And when the street's the next option, it's you see where they're coming from, but I think it's negligent on our part to force that decision, and it's something that needs to be addressed. Finally, I'll wrap up with just talking about employment. Employment is a very difficult collateral consequence to address, because the rub here is you have situations where you take a small business owner who owns a business, and then they hire somebody that has a record, and that person then steals from a patron, let's say. Well, then that patron can sue the small business owner for negligent hiring. And so the small business owner will then say, well, I can't ever risk that again. I'm never doing this again. The word spreads, and people don't want to take that risk. So what needs to be, in my mind, what we need to address on the employment front is at some point, if you've gone so many years or you've shown rehabilitation, that your previous criminal record should be irrelevant when it comes to a negligent hiring lawsuit. And that's something that the state of Illinois, the state of Connecticut have addressed, and we support that with a certificate of rehabilitation. But it's a difficult issue when you look at both sides of it. But at the end of the day, if you can't make an honest dollar, it becomes almost impossible to keep yourself from committing another crime and supporting to make money to support your family. So I think we have to look at ways to employ people once with a record. And at that point, I'm going to turn it over to Lisa, who will go over some of the solutions.
Before I speak as an attorney, I want to take an anthropological analysis of this. My sense is that if you want to reify badness, you have to find a social marker to do it. And stigma and juvenile records or adult records are the perfect reification. And if you wanted to find a system that marginalized people because of this so-called badness, because don't forget, many of the folks who are involved here are folks who've had cases that are dismissed. And there is some theory that sometimes police arrest people who haven't done something wrong. It's just a theory I've heard about, but that the people pulled into the system are immediately reified and marginalized. You could not create a better system than what we've created for juveniles. And what's not recognized is that it's not just the juvenile impacted, it is the entire constellation of that juvenile's world. So hats off to the United States with terrific symbolic inversion, propounding, promoting how much we care about kids. We are systematically really subverting their opportunities, even for kids who've been found innocent. What I want to talk today about very quickly is what our juvenile collateral consequences survey found. I'm very glad the ABA did this, and I'm very honored that Chris chose me to organize the research protocol. And what's a little bit different about the ABA study from others is we did not focus solely on court records, which is what most studies have focused on. We also looked at arrest records, because with the increasing criminalization of youth in schools, my personal experience with police shows that that is one major source of information about kids. Often quite illegally, I've had officers say, well, we know we can't give school administrators the information, so we just read it to them so there's no paper trail, which is good. Prohibition is the mother of circumvention. Anyway, in addition to looking at an overview of the systems, I'm going to suggest what are some trends in the impacts of the systems that we've seen in our nationwide study and some challenges for reform. Some of the continuum of approaches we've seen across the United States are rather remarkable, from both collecting to protecting records. So in some states you have automatic sealing at 18 or 21 or 25. You can request to have your records sealed or expunged. Remember, expunged means destroyed, but in some states it's 2 years or 5 years. In some states, all records are open to the public, and there is very little relief ever provided for police records. It's all for court records. So it's clear to me that with this level of lack of systematic or uniformity in approach, we are not seeing any state system based on empirical evidence, and this field would surely stand to benefit from an empirical analysis. Much has been conducted in the adult realm of collateral consequences about how much time is truly needed to elapse before a record no longer provides a deterrent effect, which is theoretically the source of the use of records against youth. The adultification impacts, as Chris mentioned, are not only extreme, they are incredibly varied, because let's not forget, you're an adult and you can be tried as an adult as early as the age of 10 in Vermont. Luckily, they don't have a lot of people there. Or 14 in Massachusetts, and then you're automatically transferred in North Carolina and New York at the age of 16 to the adult court, and only recently in Connecticut it changed its law last year. But let's not forget, if you are sent to adult court and return, your adult record stays, even if the case is dismissed. And we know that if you were put in court in the first place, you must have done something, right? That is the default assumption. The lack of thoughtfulness, the basic abrogation of the obligation to provide individualized justice is most clear in the fact that it's a one-size-fits-all. It's 3 years to have your record sealed if it was trespass, and it's 3 years if it was assault and battery with a dangerous weapon. This is not individualized justice as the codes promote and pretend to offer kids. And this vitiates, I think, one of the core aspects of the juvenile justice system. The states are very inconsistent in what amount of information police departments can disclose. And even when they have strict laws, you'll see in the newspapers, if you read them carefully, that they're often honored in the breach. So in Philadelphia, in Pennsylvania, for instance, the police can disclose information to employers who call if the youth has been charged with a felony and if they have engaged in something that may be an act of terror. We know that a lot of 14-year-olds, 15-year-olds are trying to overthrow the state. So it's good to know that I, as an employer, can find that out. The obligations to disclose collateral consequences are solely the burden of juvenile defenders, the least resourced, the most overworked, and least supported stakeholders in the juvenile justice system. The judges have no legal obligation to disclose this, and I don't see them embracing it anytime soon, although we're going to nudge. And the bottom line problem with this is there's also no obligation in all states to do post-dispositional advocacy for youth, so that when they do have a disposition, there's not always the secondary requirement that they help the kids get rid of their records, which is something we point out in our research because we're trying to connect the dots here and showing how the system works. Few states also actively, proactively explain the system to youth and families, and juvenile defenders are rather in the wrong here for not more affirmatively taking that bit of their record obligation to do that. And entities to which disclosure of records across the country are most typical are entities that either provide daycare or aftercare for children, after-school care for children, or any kind of care to vulnerable populations, including people in hospitals. And yet, your juvenile record, for instance, in Massachusetts, can't be accessed by a hotel owner because that's a private employer, and often private employers across the U.S. are not entitled to have access to juvenile records, excuse me. But you would argue that they're as vulnerable, right? If someone working in a hotel has access to keys, I don't see how they're any less vulnerable than someone living in a hospital for a while. And in some states, you have to disclose your juvenile record even if your case has been dismissed. You don't have the option of not having that. And in Massachusetts, that's the case, even though adult records don't have that requirement. So that's why I say consequences often swallow the crime. The trends in the impacts are really extreme in Massachusetts. In housing, for instance, it's at the point of arrest that a family faces the risk of eviction, which leads to horrifying cases. I mean, I've had 4 cases at least where a kid lives on a property that's owned by public housing, is charged with trespass even though he's on the lease, and then his family faces eviction. And frankly, there aren't enough housing attorneys. So the parents typically ask kids to leave and send them elsewhere, which is great for continuity of the schoolyard to jail yard pipeline and for really causing serious rifts. Similarly, in education in Massachusetts, DAs can notify principals when they've charged a youth with a felony, and frankly, I could go over right now to Megan and kick her with my shoe on, and that's an assault and battery with a dangerous weapon in Massachusetts. That is a felony. Boy, oh boy, I would not have finished school. And they would have, I don't want you to think I did that a lot, but they would not have, then they're indefinitely suspended. And you know cases last 3, 6, 9, 12 months, right? So good policy for not only getting them out of the employment system, but out of the school system. There are disparate impacts on poor children, okay? And we know that there are more children in the system to begin with who are poor. They are also more likely to live in public housing. They're more likely to lose public education for lack of an educational attorney because GALT provides attorneys for court, but they don't provide them for schools, much as we give lip service to saying an education is so important. We will not fund educational attorneys in America. And their need to have indigent counsel that is allowed and funded to provide post-dispositional advocacy is greater, and they don't get that. And the use of sealing, the last point I want to show you, is really a function of wealth and indigent defense leadership. Not all defense attorneys really view this as important, nor can they prioritize it, sometimes for good reason. But when they do, you see the difference. And I want to take Philadelphia. 1,200 juvenile records out of a client population of 6,000 are annually sealed or expunged. In Massachusetts, where our entire statewide population of youth in the system is 13,500, had 86 sealed in 2008. Now, the challenges to reform are huge. There's no empirical research, and if any of you are out there, Aaron, who could do some of that, that would be great, because we're going about this based on incorrect presumptions. We don't know if records serve as deterrence even. We don't know what the impact of open records are, and the time after which a record is not probative is also up to question. We need empirical research on that. We also need to know what the current system does to kids. Do they think that it's worth looking for a job? Many kids think there's no point, they're not going to get a job anywhere, which is wrong. And we don't understand the role of shame in promoting recidivism and its costs thanks to this stigma, or the lost opportunity costs that exist for a long period of time because of the implicit and explicit impacts of not working. And we know teens who work have better outcomes throughout their life. We need information disclosed on computers prior to sealing, expunging. For instance, in states that say, okay, we're going to automatically seal your record at 18. If information comes out, though, on computer systems, it's never going away. So it doesn't matter that the record is sealed at 18. It's still out there. And formal systems of disclosure, I am sure, are routinely sabotaged by informal systems of disclosure. We have formal systems of total information sharing in Massachusetts, but I know that a lot of police share a lot of information with school folks in other states too, and it's very disturbing to see how that completely undermines certain protections and it systematically puts youth at risk. There is no routine oversight or auditing of record distribution systems. When I yell at the Department of Probation Massachusetts or the Criminal History Systems Board and say, you're sending this to the wrong people, they say, oh yeah, show me proof. And I say, no, you show me proof that you weren't. Show me proof that you weren't. Well, without audits, we can't do any of this. Without independent audits by universities, we don't know where it's happening. And I am always struck, I'm thinking, who cares what I'm thinking? Boy, do they care when I talk about juvenile records. They are all over me like white on rice. And it is unbelievable how they do not want to see any challenge or reduction of their access to these records. There's some opportunities here, though. There are some solutions. One is, what I do a lot in Massachusetts is work with, I think, a usual suspect, and that is youth employment counselors, because they get these kids. And federal money right now says you have to get youth offenders more employment-oriented. And so we have state policies that collide, which say that you have to get the most heinous offenders' records out to everybody, and you, the labor sector, have to get them employed. Whoops. And guess what? We don't train the workers in the employment sector what records can be distributed and how that's going to undermine 10 months, 12 months of a training effort, because that child will never get a job in that career because that career won't hire people with records. We have to make these systems more coherent. We have to have advocates take on this work more affirmatively, and that means juvenile defenders. For instance, we have to train juvenile defenders on immigration consequences and how this is critical for when they want to plea kids on certain moral turpitude crimes. Violence is fine, by the way, but moral turpitude can get you thrown out of the United States. So let's reduce that common street walking to disorderly conduct to protect the kid and the child's family's naturalization options. And finally, we have to change the terms of the debate. And one of the things we did with absolutely no effect, but we might want to try it anyway, is try and take some of these famous folks who had juvenile records and yet went on to success and make that part of campaigns. The other thing we want to do is make kids aware of what their records are, because kids are great ambassadors of information, and it's especially helpful when the information they give out is accurate. That helps quite a bit. And the ADA is going to replicate a form of these Think About It cards that we created in Massachusetts, which are no longer accurate. These are old ones, but it's given to you as a model. We've been able to change some of the practices of the state agencies that were distributing records to make some of that not so true anymore, I'm happy to say. But all this speaks to the need for attention, and that while it seems after the effect, this critical aspect of juvenile processes must be considered implicitly and part of juvenile defense advocacy from the get-go. Thanks.
I'm going to try to go as quick as possible on just explaining to you what the ABA project actually was. What we started with was the research protocol that was created by Lisa, and it was then handed off to authors. And we've created 50 state chapters, as well as a DC chapter and a federal chapter, covering the juvenile collateral consequences in each state. And these chapters went through up to 8 steps of editing and review between authors and experts, DLA Pipers doing our citations, and editors within the American Bar Association. From there, we took these chapters and they were sent to the Justice Policy Institute. The Justice Policy Institute then scored these chapters and ranked states on numeric values based on the effect and the type of product they were creating in terms of juvenile collateral consequences. From there, we've started distribution, and the main avenue of distribution for this project we've created is a website, as you can see in front of you. This website is incredibly user-friendly for those of you with laptops out there. If you have internet in front of you, feel free to look up beforeyouplea.com. And on this website, you have this set of states, and you can click on any state you want, such as North Carolina. And what comes up in front of you is this chapter. This chapter is entirely footnoted, so people who are reading it can get to statutes, articles, and solid information beyond what is in the chapter on the juvenile collateral consequences in North Carolina. From there, you can also see the Think About It card, which is, as Lisa was just mentioning, that we've created. These cards are also going to be distributed.
Yeah, I'll hand them out.
Thank you. Throughout the states in the country. Each state has an individual card. The card lists an overview of collateral consequences in that state that can be given to a juvenile before he or she makes final decisions. On the back of the cards, it also gives you quick references to relevant statutes and information in that state. Finally, the other big thing that we did was this JPI scoring that took place. At the top of the website, it lists the JPI score. You can't see it too well on there, but when you go to that score, it brings you up to this spreadsheet. These scores were made up of a series of questions on different topics. These different topics were transfer to adult court, access of records, sealing and expungement, suspension and expulsion from school, driver's license suspension, sex offender registration, and higher education. As you can see, these questions are given numeric values, and on a yes or no basis, these questions add up and give you the final score for each state. For example, North Carolina has a score of 31 on a 100-point scale. Surprisingly, this is an average score for the United States, unfortunately. And hopefully we will see as these scores come out for each state and this database comes out, states will be able to look at this and move for reform. The other large thing about this website that you will see is it's meant to be a changing, breathing document, so to speak. It's put together in a Wikipedia format. Anyone who knows information or knows any changes in legislation can go to a state, and they can, the comment's at the bottom of the chapter. Okay. You can leave a comment. You can leave information about laws changing, new legislation, anything that you think is relevant. The comment will then be sent to an email address with the ABA where it will be reviewed and potentially inserted if it's correct information. And anytime, anyone can continue updating and changing these chapters so they can stay relevant and important throughout each state. And that's pretty much everything about the website and the project. Feel free to look up the website. It's not fully up for all 50 states. North Carolina is up and ready to go entirely, but the chapters will slowly be going up, and it should be done in April entirely. Thank you very much.
Thank you.
Maybe we should sit over there and watch it.
All right. Well, good morning, everybody. This is a tough three-circus act to follow. That's a lot of information. And before I begin, I want to I actually have a couple comments I want to give about all this great information. First, it's wonderful to see so much thinking and so much work on schools, the school-to-prison pipeline, and problems in schools. I'm a sociologist and sometimes not as well versed in what the legal community is producing, and so it's great to see this. I recently completed or published a book on this issue that was a result of several years of NSF-funded research, and though I'm not going to talk about that today, it's nice to know that the community is broader than I had realized. Two, one thing that was mentioned a couple times is whether or not arrest has and adjudication have a deterrent effect for juveniles. And there's been some really interesting work done on this in the criminology community. Al Blumstein is a very prominent criminologist at Johns Hopkins. He has a co-author at University of Maryland. And though it's hard to know whether or not there's a specific deterrent effect as opposed to just being excluded from opportunities, what they've done is look at, for offenders generally, the survival rates or people rearrest rates over time, and how after, I believe it's 18 to 20 months, the likelihood of being rearrested for people with a record is just about that of other people, so in a relatively short period of time, in other words, there's no effect of it in terms of re-arrest. So I think there are some interesting parallels. But none of that is what I want to talk to you about today. What I do want to talk to you about today is juvenile incarceration and the pains of imprisonment. And I'm Aaron Kupchik, and I'm at the University of Delaware, as Brian so nicely pointed out before. I want to start by thinking about the criminalization movement that we saw beginning across the country since the 1970s. The impulse to criminalize, as we pointed out before, has been very, very strong. And since this time, the boundary between juvenile and criminal courts, between these two justice systems, has been completely redrawn. And we heard about this earlier, about the transfer to criminal court. I agree this is a pressing problem, and a lot of my work has looked at this. By about 2000, this is an estimate. It's impossible to know precisely because we don't count it, but there are about 250,000 minors under age 18 in criminal courts across the country. Many of these kids get sent to adult facilities, adult correctional facilities. The peak of this in 1996 was about 5,400 minors in adult prisons. Again, these are estimates. I'm always very skeptical of the quality of these data because not all states report similarly, and they don't all report good data. But if we look at it over time, it's kind of let me take you through this shot. The kind of curved bar line up top with the squares, these are new admissions to adult facilities of kids under 18. And we see that it went up a ton, up to about 96 when it was at its peak, and then has trailed off. New admissions are still much higher than they were at the beginning of the time series. The diamonds, the curved line, in the middle, these are, this is the census of how many inmates under 18 are currently inside adult prisons. And this went up a lot during that time and has gone back down. The comparison line that keeps going up, these are inmates 18 years old and older, and this is through 2004, so it's a little bit dated now. So we see that this is a big problem, perhaps not as much of a problem as it was 15 years ago, but a substantial one that we must deal with in talking about collateral consequences. Now, why is adult incarceration bad? What are the consequences and the collateral consequences of adult incarceration? There are all sorts of them, and I'm going to go through them very briefly, but there's a pretty well-developed prior literature discussing this and looking at this problem. Recidivism rates are higher when kids go to the adult system and when they're incarcerated through the adult system. We've already heard quite a bit about this. Employment, student loan prospects, future avenues for success are cut off. Inside adult prisons, prior research finds that services are not only poor, but not age appropriate. So kids in adult facilities can't get kids' needs met. They don't have the proper educational facilities. They don't have proper counseling capabilities. There are all sorts of deficiencies. Prior research also shows us that the conditions of confinement are pretty stark. Sexual assault has been found to be higher. Physical assault has been found to be higher. Emotional injury, all these problems of kids doing time in adult facilities, they're at greater risk for further damage. Kids are surrounded by older inmates. This might be problematic, it might cause fear. Some studies find that, if you talk to a warden of a prison that houses kids, they might tell you that most of them would probably tell you that the juveniles who get sent there are the worst. Right? They're the most violent ones. If there's a problem, they're usually the ones who start it. Now, is this because they're so damaged when they come in, or is this because they're acting tough to hold their own, or because they're scared and trying to avoid victimization? They're also, as I mentioned before, often victimized. Finally, incarcerating youth in their critical years of development in the harshest, least helpful situation possible, adult facilities, obviously has a host of future problems ahead. But what if we compare juvenile facilities and adult facilities? And a lot of the literature has done this as well. Now, there are certainly big differences between the two types of facilities. Right? Juvenile facilities are softer environments. Staff can wear casual clothes versus your formal correctional guard uniform. the physical security tends to be less. It looks somewhat more like college campus relative to adult prisons. Most, not all. Movement is, well, a little, the restrictions on movement are somewhat lighter. And they have to have schools by law. So there's somewhat greater attention to education. The comparative research shows that kids in juvenile facilities get more help. They're less likely to be victimized. That the relations, which we know are very important between youth and staff in juvenile facilities are better mentoring relations. There we go, backfilling. That feelings of safety are greater in juvenile facilities. And that the kids' ratings themselves, youth inmates' ratings, are more positive in juvenile facilities. But all of this is where most of the recent research looking at the criminalization movement and looking at consequences of juvenile incarceration have been, comparing juvenile facilities to adult facilities. And the clear answer is looking at this is that, you know, prosecuting and punishing kids in adult facilities is a bad idea. It leads to bad outcomes. But we're approaching this paper thinking that there's a problem in thinking this way and thinking in a binary way. Because what this does is subtly minimizes the pains of juvenile incarceration and the consequences of juvenile incarceration. Yes, absolutely, juvenile facilities might be much better than adult facilities, but they're still really bad. And we've lost sight of this a little bit in making this comparison. Juvenile facilities still are correctional facilities. Their focus is on security first and foremost, like any correctional facility would have. These are still kids who are moved, in some cases, especially from urban centers, many, many miles from their families, where they have little contact with the outside world, with their families, with their support networks. And though it might be monitored less strictly than in adult facilities, their movement is very tightly regulated. They have no privacy, and education and treatment are kind of afterthoughts. Again, comparatively, they might be better than in adult facilities, but there are still problems. We learn a big lesson from Jerome Miller's experience in the early 1970s. Jerome Miller, I imagine many of you know, was the head of the Massachusetts Department of Corrections at a time of the late 60s, I believe he was appointed in 67. Does that sound about right? And what he did when he took over was realize that, man, this system is just in shambles and kids are getting horrible, horrible treatment. So he tried piecemeal to change things by improving education, improving counseling, making it safer. And everybody resisted. The institutions were set up to do things in a particular way, and that was to incarcerate and punish. And he couldn't get any of his reforms implemented, so he closed shop. He closed all of Massachusetts' juvenile correctional facilities. Of course, that hasn't stayed true until today, but Massachusetts, relative to other states, does pretty well in a whole lot of measures, and in large part thanks to Jerome Miller's efforts. Okay, so my point is that we need to think not just about this comparison, but also think a little more critically about what juvenile facilities are doing. And we've seen a lot of this happening. In recent years, several states' juvenile justice systems have been under attack through recent litigation. Just a few months ago, New York State, their Office of Children and Family Services, for example, agreed to federal oversight of all of their facilities after investigations found rampant abuses. In some cases, facilities with 0 counselors on staff for juvenile prisons. California and Texas, this joins a long history of litigation, which I imagine many of them are more familiar with than I am. And we think that this is just the tip of the iceberg, though. When you think about juvenile inmates, they have the least social and political capital of just about anyone in our society. Right? They're poor, they're uneducated, they're minors, so they can't formally file grievances, legal grievances. They don't have access to attorneys most of the time. I mean, they have, and when they do complain, they're often dismissed as being just kids complaining, right? So they have such little power to register complaints that, there's obviously some anecdotal evidence suggesting, or more than anecdotal, I guess, suggesting that conditions in juvenile facilities, we need another look. Not just comparative views where we compare them to adult facilities, but an absolute view. In other words, while transfer is very important, while transfer is crucial, in fact, most kids are still sent to juvenile facilities, and we need to better understand them. So, what we did, I'm going to continue to present some empirical research where we interviewed a lot of young adults and youth, all under age 21, all young males, from 3 northeastern counties in New Jersey and from 3 boroughs of New York City, 3 counties in New York City. Now, the kids in New York City were both in facilities run by the juvenile system and facilities run by the adult system, but all of these kids were prosecuted through the adult system. Okay, they were all either 16 or older, so they were considered adults, or they were waived up to the adult system because of their offense. So we kind of have 3 tiers here. A full juvenile system, kind of a middle ground. Kids were prosecuted in adult courts but sent to juvenile facilities, and then the adult system. We did in-depth interviews with them, comparing kids across these 2. They were matched along many criteria. These kids all live in the same metropolitan statistical area. I'll go quickly through my methods. And we asked them a whole lot of questions. Many of them had scaled response options. Here are the things that I'm going to discuss that we're measuring. A list of what we tried to do is capture their correctional experiences, from what kinds of services are available to the individualized counseling and help that they receive, whether they witness crime, whether they're victims of crime, whether they commit crime or drug or alcohol use. And then towards the bottom here, we include a series of measures looking at their psychological functioning. Our BSI, Brief Symptom Inventory, is a well-used measurement tool, looking at problems like obsessive compulsiveness, depression, and anxiety, and then PTSD, post-traumatic stress disorder, looking at several different elements of PTSD as found in the literature. My first graph really surprised me when I first looked at this. If you look at the left, the black bar, the way each of these slides goes, the checkered bar on the left, these are our New Jersey, the fully juvenile facilities. The ones in the middle are kind of the hybrid, the kids transferred to adult court but sent to juvenile facilities. And then the black bar on the right, these are the adult facilities. The kids in these facilities are far more likely to report that they have access to institutional services like, believe it or not, education, law library, counseling, medicine, than our kids in the other facilities. Exactly the opposite what the prior literature would lead you to predict. Our second one is, I think this was missing from the previous slide. This is an important one, procedural justice. And this has to do with the youth's perceptions of whether staff are fair and whether the authority in the facility is legitimate. There we see that the adult facilities have the lowest. And the third, individualization, there aren't very clear comparisons one can make here. When we look at disorder and crime, the results are also surprising. Exactly opposite of what prior literature would have you predict, there seems to be the most violence, victimization, self-reported crime, and self-reported drug and alcohol use in the juvenile facilities and the least in the adult facilities. Exactly the opposite of what you would predict. Now, one takeaway so far is that juvenile facilities are still quite painful. And kids are not getting the services they need, and they are exposed. And so saving them from adult facilities is certainly not sufficient. Looking at whether or not, what we did was we ran regression models, ordinary least squares regression, to see whether or not these results hold up while controlling for their age, race, whether they're incarcerated for a violent offense, and they do. Each of these results does hold up. The procedural justice score is significantly lower in the adult facilities, and the institutional scale is significantly higher. The same is true for each of the disorder and crime, that the scores are lower in the New York Department of Corrections kids. I know there's a lot here. On this, you try to make things simpler by putting up graphics instead of numbers, but then you get caught showing a slide like this, I guess it doesn't help. These are the brief symptom inventory, the different parts. All the way on the right is the global brief symptom inventory, which sums up all of the others. And if we just start on the right, we see that the adult facility kids show the highest level, and this is statistically significant, the highest levels of especially depression, anxiety, hostility, phobias, of psychological disorders. So they might be exposed to less violence, but these kids are functioning, their mental health is worse. And all the ones to the left are different aspects of that. The ones that are significant, if you look, 4 in depression, the depression levels of the kids in the adult facilities are really high, much higher than the others. To the right of that, anxiety, much higher in the adult facilities. Phobias, substantially higher in the adult facilities. So psychologically, they're not doing very well at all. Here are the post-traumatic stress disorder results, even clearer. The kids in the adult facilities do much worse. These kids are getting scarred in the adult facilities. And the juvenile facility respondents report lower levels of post-traumatic stress disorder. These hold up as well when looking at multivariate results controlling for, again, the same independent variables, age and incarceration, and race, violent offense. So what do I make of all this, and how do I sum this all up? It's not as clear of a comparison as one might have expected based on the prior literature. The kids in the adult facility rate institutional service access better. But at the same time, they rate their interactions with staff less favorably. So we're providing services, but not following through, right? The quality of the services is poor. Adult facilities seem to be safer, completely contradicting prior work, but fear is higher. I didn't show these results, but I think this is important. The percentage of kids who said they feel in danger all of the time is 19.7%, about 20% said they feel in danger all of the time in adult facilities versus 10% in the juvenile facilities, twice as many. The percent who say they feel in some danger, again, about twice as high in the adult facility as opposed to the juvenile facilities. So kind of paradoxically, there might be less crime and violence in the adult facilities, but these kids are more scared and more scarred based on what's going on, because mental illness and PTSD rates are much higher. So the adult facilities do maintain security and offer services, but have a host of problems beyond that still make them inhospitable places. Our conclusions. First, we don't depart from prior literature, even though it's not as clear as we expected to find it. Juvenile facilities are still the better option for youth and young adults. It is still a mistake, it seems, to send kids up to adult system. Pardon me. To be incarcerated in adult facilities. But here's what we're adding to this. In addition to recent, the first point we're updating and expanding on based on prior literature. But this prior literature, we think, minimizes the second point. Incarceration needs to only be used as a last resort. We over-incarcerate, as everyone in this room, I'm sure, knows. But what we're showing is that when we can make this comparison of juvenile to adult, certainly it's helpful in some ways, and we have an answer. But at the same time, juvenile facilities still do not do a good job. These are not, they might be a better option, but they are far from a good option. What we're trying to argue in sum is that we need to focus much more on advocating for kids. Not just advocating so that they get removed from the adult system, but trying to make sure that they stay out of any system. One final thought about this is, as we compiled these results, we thought, well, why were our results so different than what studies found just 15 or so years ago, finding that crime and violence were higher in adult facilities? Our suspicion, and this is a hypothesis, is that conditions in the juvenile facility have deteriorated because we've been focusing so much nationwide on pumping money into expanding adult prisons. As in mass incarceration was at its peak in the 90s and up to 2000 or so, so much, seemingly limitless funding was sent to expanding the number of prison beds, with a relative lack of attention to juvenile facilities. So compared to, relative to the results found 15 years ago, juvenile facilities seem to have gotten worse. That staff training, service delivery is worse, and the ability to supervise kids and keep them safe. Thank you very much.
All right, Good morning, everyone. My name is Riya Shah, and I'm an attorney with Juvenile Law Center. We're a national public interest law firm based in Philadelphia. And this is my colleague, Lisa Campbell, who's a public defender at the Defender Association of Philadelphia. So you've heard a lot about the different consequences and the severity of the consequences that result from juvenile adjudications. But one thing that we want to talk about today is that even though these consequences are so severe and the penalties are so grave, courts have consistently said that these are non-punitive consequences, and therefore they're really outside the realm of what anybody has an obligation to inform kids about. So our article actually looked at, and also because ineffective assistance of counsel claims have been unsuccessful in these with these issues, our article is looking at the recent Supreme Court decision in Padilla versus Kentucky, which establishes an obligation for counsel to advise clients of the immigration consequences of a guilty plea. We think that this case has now opened the door for new argument on this issue. So we're going to be talking about why it's particularly important for communicating these consequences to youth because of their underdeveloped sense of self and their adolescent development. We're also going to be talking about the standards across the country that favor communicating these consequences to kids, and then finally talking a little bit about the ineffective assistance of counsel argument and using that in the more severe cases where severe punishments are applied to kids. So I'm going to turn it over to Lisa, who's going to talk a little bit about Padilla.
Padilla versus Kentucky was decided last year on March 31st, 2010. And just briefly, Jose Padilla was he came from Honduras. He lived in the United States for over 40 years. He was a lawful permanent resident. He was a Vietnam vet, and he ended up pleading guilty to transportation of a large amount of marijuana. He did so. His claim was on advice of counsel that it would not, basically he said he didn't have anything to worry about his immigration status because he had been in the country for so long. Obviously, under federal law, he was facing automatic deportation. Because of that, he said that his lawyer had been ineffective and that he would not have entered into his plea and he would have insisted on going to trial. The Supreme Court held that he was required to have constitutionally competent counsel, and that counsel would have advised him that his conviction subjected him to automatic deportation. The court also held that it was not just the misinformation that the advice the conviction didn't affect his deportation, but that counsel should have advised him correctly and should have, that silence wasn't enough, that he should have advised him affirmatively. So just quickly, I want to go over some of the legal reasoning of Padilla so that we can then apply it to juvenile adjudication collateral consequences. First, the court looked at the changing legal landscape of immigration law, and they said that what had started out decades ago for immigration law had changed now into the drastic measures of removal that was nearly virtually inevitable. Judges used to have authority to alleviate, and now that that measure had been basically taken away by the law. They said, they used the language that the changes had raised the stakes of the non-citizens' criminal convictions. And the deportation is an integral part, and sometimes they said the most important part of the penalty, which when we talk about some of the collateral consequences later, we think basically is the same thing, that they're so intimately related to the criminal process, in this case adjudications of delinquency, that you can't separate the two. So the court does recognize that deportation and removal proceedings are civil procedures, but they're so, like I said, intimately related that it's difficult to divorce the two penalties. So it does look at both professional norms, and what they look at is like the National Legal Aid and Defender Association standards, ABA standards, amongst other sources. I think one of the footnotes cites over 20 different sources in looking at what the prevailing professional standards are. It acknowledges that immigration law can be complex and it's a legal specialty of its own, and it also says that the terms of the relevant immigration statute are, that specifically are succinct, clear, and explicit. So basically that the attorney in Padilla's case could have simply looked it up, found out about it. In certain cases, it could be more complex, and he should have said that there are immigration consequences. But in Padilla's case, it would have been simple to say there are immigration consequences, and deportation is nearly automatic. So those are the kind of broad stroke legal reasoning that the Supreme Court looks at in Padilla.
Okay, so I want to address a couple of those arguments and how they apply in the juvenile context. So first, Padilla argued that, or reasoned that immigration law had changed dramatically over the last 100 years, making far more punitive consequences for individuals and creating a broader class of deportable offenses. Well, when we in the juvenile community looked at this, we said, well, you know what? The juvenile justice system has changed quite a bit over the last 100 years. In the beginning, something that was thought of to be purely rehabilitative and thought of to be civil and not criminal in any way, shape, or form has now changed. And in the 80s and 90s, there was an increase in juvenile crime, and as a result, there were a lot of policies that were created, these get tough policies that really enforce the adult time for adult crime type of attitude. And it resulted in a lot of states changing their the purpose of their juvenile acts. So we had states that actually changed the purpose clause of their juvenile codes to say, rather than having a rehabilitative system, we're going to have a punitive system with rehabilitation, or we're going to have a balanced system that weighs punishment and rehabilitation equally. There's also been lots of changes to juvenile justice systems across the country that eliminate some of those long-standing features of what we thought the juvenile system was based upon, like confidentiality of records and closed court proceedings and a proceeding that provides treatment as opposed to just punishment. So part of this feeds into this idea that even though the system has changed so much over time, public perception really still remains that when you do something as a juvenile, when you become an adult, it no longer affects you. And so that's why the duty to communicate the consequences of a juvenile adjudication is so important, because they're less, families and youth are less likely to imagine what those punitive consequences may be when they have this idea that, it's going to all go away once I turn 18. Another thing that Padilla reasoned was that immigration law is complex and that it's a legal specialty of its own. Well, so is juvenile law. Juvenile defense is similarly a specialty. There's a whole different body of case law for motions to suppress, for competency hearings, among other issues, in addition to standard case law and criminal procedure that's used in the adult justice system. Attorneys have to know the nomenclature that's unheard of in adult court, and they have to know the services that are available to youth. So defense attorneys, in addition to just having to try their case, also have to make recommendations about appropriate dispositions for juveniles. They have to understand child and adolescent development from a psychological perspective as well as from a legal perspective. They have to be able to address family issues. So if there are parents involved in the case, and relationships between parents and children, and then also issues regarding the determination of the objectives of their representation and who their client is. And standards support providing defendants information about the consequences of their adjudications, and also support the idea that juvenile clients should be treated in the same way as adult clients, in that attorneys should provide them that same type of relationship, attorney-client relationship. So while the ABA juvenile justice standards don't actually address communication of collateral consequences, the ABA and NLADA standards for adults actually do favor the communication of collateral consequences. So we think that that can be extended to juveniles as well. And then the other thing that I want to talk about is how adolescent development really does play into this, because as we've heard in Roper and Graham, the Supreme Court has consistently recognized that juveniles are different from adults, that they're less mature and they're less able to weigh the risks and consequences of their actions, and they're more vulnerable to external pressures and more compliant with authority figures than adults. So therefore, there should be a higher standard for representation of juveniles. Kids don't think of the immediate consequences of their actions, so let alone the future consequences of their actions. You know, there's a commercial that's like a TV commercial that's out right now for some insurance company where there's this guy standing over a cliff with like rocks underneath him, and he's like, "Can you believe that when I was a kid I used to swing over this? I was so stupid, I did such stupid things when I was a kid." And I saw that commercial, and I was like, yay, it's like the public is acknowledging that, yes, kids are different. So I do think that it's because, while we do have this, while we know that kids do stupid things when they're younger and they do things without thinking about the consequences of it, when it comes to the justice system, we are less, as a society, we're less likely to give them the benefit of that acknowledgement. So I do think that when you think about it in the context of communication of collateral consequences, you have to keep that in mind, that kids are present-oriented thinking. It interferes with their ability to engage in adult-like thinking. They're unable to think about the future. They discount the future and weigh more heavily on the short-term risks. They really don't understand deterrence. You know, when we talk about whether or not getting put into the justice system is going to cause kids to not participate in delinquent behavior, you know, that's one large consequence. But if you talk to them about, well, this may sometime down the road affect your ability to get into college or affect your ability to get a job, that's just so far removed from what they're thinking about. So as a result of that, we really believe that favors an argument that defense attorneys have an obligation, and court personnel generally have an obligation to inform juveniles of the consequences of their adjudications. So we argue in our article for using the ineffective assistance of counsel standard under Strickland v. Washington that says that you need two prongs. You need deficiency and prejudice. In Padilla, the attorney misinformed him that there would likely be no severe immigration consequences, and so it was held that was deficient. So when you think about this from the standpoint of plea negotiation, juveniles actually plea at far greater rates than adults, and that may be for those reasons that I mentioned related to adolescent development, that they don't have the same ability to think through the consequences of entering a plea, that they may feel pressured to enter a plea without understanding what the consequences are. But if you aren't communicating what those consequences are to kids, then they aren't able to enter into a plea without full knowledge of what's before them. And one quote that I really love is that teenagers are fairness fanatics. And while, you know, everybody that's in the justice system really is, you know, believes in getting a fair trial and getting a fair shake, teenagers are especially concerned with being treated fairly. And if they're not told of what those consequences are prior to entering a plea, then that really fosters cynicism and mistrust in the system. And so I just want to say one more thing before I turn it back to Lisa to talk more about ineffective assistance, is that in Padilla, this whole thing came about because it was a post-dispositional, it was a post-conviction relief petition that Padilla filed in order to get the plea withdrawn. In most states, juveniles don't have post-conviction relief or post-dispositional relief, so it's really important prior to plea and prior to adjudication that these communications are made with juveniles, because they don't have the same ability to challenge their dispositions through a post-dispositional relief. And while they may have the ability to appeal their actions, once you enter in a plea, usually you lose that ability. And even if you do have the ability to appeal, often the time it takes to file an appeal is so lengthy that the appeal is meaningless because you've already fulfilled your entire disposition.
What I'm going to do next is apply the Padilla framework to two specific statutes that are currently in place. Obviously, we'd love to see the Padilla framework applied to all collateral consequences, but we're applying it to two of the most severe and two that certainly rise the Padilla immigration-like consequences. One is, the first one I'm going to talk about briefly is the Adam Walsh Child Protection and Safety Act, which is also known as the Sex Offender Registration and Notification Act. I'm going to call it SORNA for short. This was signed into law July 27, 2006, and all states have to substantially comply with SORNA, or they're going to risk forfeiting basically 10% of federal funding that comes in through a federal act. What it is basically is lifetime registration if a juvenile who's 14 or older is adjudicated delinquent of certain sex offenses. It's usually with any degree of genital or anal penetration and or oral or genital or oral and anal contact. Usually there's a force or threat of force. And what I want to point out is that this is a floor, not a ceiling. So most states have a higher registration qualification. There's several states that only have the bare minimum to qualify for SORNA, but a lot of states will have, Delaware, for instance, have people who are 12 and older have to register under SORNA. Pennsylvania is not yet in compliance with SORNA, but once it comes into compliance, it will be retroactive to 2006. So anyone who has admitted to a sex offense or has been found guilty of a sex offense, even if it goes back to, let's say, August 1st in 2006, will have to register under SORNA, depending on how Pennsylvania comes into compliance with it. I say it's lifetime registration. Everyone usually says it's 25 years to life for these offenses. It's lifetime registration, although you can come off of the registry if you have certain qualifications, which is basically you have to complete your sex offender treatment, you have to not be convicted of any new sex offenses or felonies, you have to complete your probation without revocation, and then you have to petition to be removed from the registry. So it's basically lifetime registration. If you can imagine, if you're in Delaware, lifetime registration for a 12-year-old is something that is frankly incomprehensible, and it's a far greater penalty than the year of probation you might do or the even year of placement you might do in one of these placements that we're talking about. And the other issue that I want to point out is that it's also, it's hard for lawyers to figure out, but it's really hard for kids to figure out who are 17 years old and live in Pennsylvania where there is no SORNA right now, and then decide to move across the river to Delaware where there is lifetime registration, and then they have to then start registering, or they move to Virginia or move to Utah or any of these states where that have different laws. So even though SORNA was supposed to have every place come into compliance with the same law, there's different laws all over the country. So these kids are now having to register for completely different laws. So this is a law that, in the adult context, Megan's Law were prior to Padilla thought of as strictly a collateral consequence, and lawyers didn't have to tell their clients about, but I'll talk about in a moment whether Padilla or not we think should apply. Next, what I wanted to describe briefly is involuntary civil commitment. This is something that exists in several states. I'm going to talk about Pennsylvania because that's the act that I'm most familiar with. We call it Act 21. Basically, if you're adjudicated delinquent of rape, involuntary deviant sexual intercourse, or indecent assault, or 3 other sex crimes, you're committed to a facility and you remain there at age 20, and then you have a finding from a sexual offender assessment board that you need continued involuntary treatment because of some sort of mental abnormality that they think you're going to be more likely to engage in sexual violence. You can be involuntarily committed civilly for up to 1 year to the rest of your life. There's reviews every year, but to the best of my knowledge, anyone who has been committed involuntarily has not yet gotten out. So even though there's reviews every single year, no one's gotten out. So it's basically involuntarily indefinite commitment. So again, this is and it's not a criminal statute, and so there's no, you as an adult, you get a 3 to 6 year sentence, and then you max out at a certain point. At this point, it's an indefinite commitment, even though there is a 1 year review. In Pennsylvania, pretty much days before Padilla came down, the Superior Court said that this was a civil procedure, and therefore there was you didn't have to tell your client about it. However, we would argue strongly that Padilla should be applied to this, and there's a duty to advise your clients about this. We think that if immigration, where removal is the most serious of consequence, that certainly lifetime registration and indefinite involuntary civil commitment, where your very freedom is taken away, rises to that same level. Applying what Riya and I have just talked about, prevailing professional norms certainly support it, and in our article we rely on NLADA, ABA standards, and other sources. It's certainly nearly automatic. As registration goes, it's offense specific, and that's the only thing that triggers it. There's a little bit less clarity for Act 21 because when you either plead or you're found guilty, you have the offense specific, but then you still have to have the SOAB finding and have to still be in placement. However, our argument to that is all you have to do is, if you're found guilty of one of those 6 offenses, advise your client this is a possibility, because it also gives your client the opportunity to try to get out of placement before the time he's 21 so that he makes sure he's not in that position. So it provides him with an incentive to be out of placement at that time, and he's also warned duly. It's certainly a drastic measure. Like I just said, that I'm not sure if there's anything more drastic than having your freedom removed for the rest of your life, or having to register as a sex offender, where it could go on the web, your photo, your job, your school. And it's certainly succinct, clear, and explicit, even more so than the immigration law. It's, I think, less complex than immigration law is. And just as a side note, in Padilla, it said that this would only help both sides, that counsel could craft a plea that avoids these immigration consequences, that you could plead to something that would avoid removal proceedings. It's the exact same thing, that if counsel is up to date with registration or involuntary civil commitment, they could craft something where your client, if he knew those, may be more likely to plead guilty to a lesser offense that would avoid these consequences, so that he could avoid lifetime involuntary civil commitment or registration. On the other hand, he would be less likely to plead guilty to something, even though it may get him out of detention center quickly, knowing that the rest of his life he'd be burdened with these offenses. But we would argue that these are not hard things for attorneys to become up to date with. I mean, you've got the ABA map right there that you could go to. In Pennsylvania, we have the Pennsylvania Juvenile Collateral Consequence Checklist that we've disseminated, and we're disseminating to attorneys across the state. We would also argue that judges have a role in this. The Juvenile Commission, what's JCJC stand for?
Juvenile Court Judges Commission.
Juvenile Court Judges Commission had a model colloquy for SORNA, so that they are encouraging judges throughout the state to give, each time there's an Adam Walsh Act, every time there's a SORNA level offense, so that it's 4 pages long, and it's I think to discourage any youth from admitting to a SORNA level offense without fully knowing. So an attorney should go over that with their client before they plead guilty to anything, and then the judge would go over with it too. So there's 2 checks and balances before any kid pleads guilty. And that went into effect after 2006, but before, obviously, Pennsylvania has even adopted SORNA or come into compliance with it. And the ABA standards even, they don't say that a judge is required to do that, but it certainly encourages the judges to do that. And the cases that have come down post-Padilla, interpreting adult Megan's Law and some juvenile SORNA cases, have come into the same opinion that we do, is that Padilla should be interpreted that a counsel has a duty to inform their clients of these types of collateral consequences. So we would say that if the courts obviously have to take Padilla seriously and take immigration seriously, that juvenile attorneys should take their duty seriously, that we think that the cases will be coming down state by state quickly, and that as a public defender, that it's our duty to inform our clients of these exceptionally serious collateral consequences. And rather than waiting for courts to tell us what our duty is, rather than waiting to be found ineffective, that it's our duty to get ahead of the curve and start telling our clients, if we're not already doing that, informing them not just about Act 21 and SORNA, but all of these collateral consequences, because although we are overburdened and overworked, I don't know of anything that's more important than representing our clients fully.
I guess we have a few minutes for questions, so if there's any.
May I just add two things quickly? Just so you know, the American Bar Association views that sharing burdens is a good idea. And so when we go to the National Council of Family and Juvenile Court Judges, we're going to promote a colloquy that we're working on with several judges to suggest to them, get them ahead of the curve before it's imposed on them, to join in the fray here, especially with the increased criminalization and the increased use of collateral consequences. I also want to say that the National Juvenile Defender Center just commissioned a study of all juvenile defense standards across the United States to create, for the MacArthur Models for Change project, nationwide standards for juvenile defense. And it was very striking to me, because I worked on that project, that of the 14 existing juvenile defense standards, that's all there are in the United States, and there are more states than that, only 2, including Pennsylvania, even mention collateral consequences. So there's a lot of work to be done in this, and I think the NJDC's new standards will be different in that you'll see integrated into every aspect of the proceedings consideration of collateral consequences in recognition of their huge impact.
So are there any questions we could take?
So I'm wondering for the ABA folks whether you're directing any of your efforts toward trying to educate or change the attitude of prosecutors in juvenile court toward the consequences that we are discussing today, and let me just leave it at that, because I know there are prosecutors' offices that take the position that collateral consequences are not our problem. We're charging them as we see them, and if someone's going to be deported or kicked out of school or evicted, not our issue.
Yeah, I mean, you're absolutely right. I mean, the woman that actually started this, who's sort of, the brainchild behind this, was Kate Rickman, and she is actually the head juvenile prosecutor in Minnesota, Ramsey County, which is St. Paul, and we have a lot of prosecutors working on this with us, and that's one of the beauties about the ABA is that we have both sides represented, and I think prosecutors are looking at it. We're getting some buy-in, especially after Padilla, because they don't want to see a case come back, and so now if ineffective assistance of counsel is opened up now, the door's now been opened, their interest is in developing waivers or something that say, do you acknowledge that your attorneys, told you about everything that has to do with collateral consequences, sign here or something. So, but you're right. In reality, in practice, it's a tough argument. The argument I make, which I make all the time when I'm in plea negotiations, is that, when I'm trying to ask them to consider collateral consequences in determining their plea, it's hit or miss. But it's definitely part of our effort to educate prosecutors and to get these think about it cards into the courtroom. And, and I think finally, this idea of a new judicial colloquy is really an important one. And the other side of this that we haven't discussed is that when you look at an average judicial colloquy right now lasts about 10 minutes. I mean, it's painfully long right now in a juvenile court. And if we're going to ask the judge to now, keep adding things, all these different collateral consequences, everyone's going to get frustrated. The prosecutor's going to get frustrated because they're going to, the calendar's going to last so long. The judges are going to miss tea times. I mean, and eventually I think you're going to see a real groundswell that to change some laws here and to get rid of some of these collateral consequences when we're asked to, when everyone is required to notify.
Because of tea times.
Tea times is the key, yeah.
I want to mention one thing, that the ABA juvenile justice section of the criminal justice section, or whatever it is that it's called, while there isn't a resolution or standards on informing youth of collateral consequences. They have released a resolution on limiting collateral consequences, so directing employers to not use juvenile adjudications in against kids. So and all sorts of other things. So that is one other thing that we think supports this view.
Any other questions? Okay, well, I think we went a little over time. So.
I want to also point out an advocacy example. In Minnesota, there's an organization called Second Chances, and in Youth Today, there was an article on January 26th about their effort to bring attention to this, because not only do kids think that their records are sealed automatically, judges and legislators think so too. And so this kind of awareness effort, much like those postcards that we did, is useful. And it's a very interesting and persuasive approach, which Kate Rickman, the co-chair of the Juvenile Justice Committee, is using and supports. So if you're looking for other alternatives, this is an interesting idea. I can give you more detailed information about it.
Thank you all.
Thank you.